I think the first thing you need to understand is that we have brought an action against juvenile court judges in the state of Texas and have established a class of defendants of all juvenile court judges in the state. The reason for that is that we found that and have proved in the court action subsequently that a large number of juveniles have not had lawyers in juvenile court, and that's really our first cause of action in the lawsuit. The second half of the lawsuit deals with the access of juveniles who are in state schools, that is, schools run by the Texas Youth Council, and deals with the access of those juveniles to lawyers and to courts from within the schools, so that there are really two aspects to when a child gets a lawyer.
Now, in that lawsuit, the federal judge sent a questionnaire to 2,000 of the inmates.
Yes, a little more.
Asking them if they'd had counsel when they went through the juvenile court process. What was the response to that questionnaire?
Well, there's a difficulty with the questionnaire because I think it may be that some of the juveniles did not understand the questionnaire when they filled it out. However, an affidavit has been filed in the lawsuit stating that the questionnaires revealed something over 60%, I believe, or perhaps 55% of the juveniles did not have lawyers when they went through the juvenile court process.
Do you have any statistics on what the situation is in Dallas, Texas?
Well, when we first filed the lawsuit, we asked for information specifically about Dallas, Texas, and learned that over 90% of the juveniles that went through the Dallas juvenile court system and ended up in state schools did not have lawyers when they went through the juvenile court system. That apparently has changed since we filed the lawsuit.
The other aspect of your lawsuit is very intriguing. In your brief, you allege that the superintendent at these state schools have refused to deliver mail between inmates and their private counsel, and refused to let the inmates, the juveniles, confer with their attorneys in private. And there's even one count that says that the people at the state schools actively intimidate inmates from seeking counsel.
It is apparently a regulation of the Texas Youth Council that all mail from children in the schools will be censored and is censored. We have an order from the court that says that children who write to us, if we have an attorney-client relationship with those children, can do so without having their mail censored. But that's as far as that aspect of the case has gone so far.
When the juvenile courts were created in 1899, it was as an alternative to what was at that time a discredited adult penal system. From your experiences in juvenile law, do you think that the safeguards provided by the juvenile system have been effective in protecting children against abuse?
Well, the Supreme Court in 1967, when it decided the case of In re Galt, saying that juveniles had to have lawyers, said that the purpose of the juvenile court is rehabilitation, and that is the juvenile court system is to rehabilitate children, and said that that seems to be failing. That's true nationwide. That the recidivism, that is the number of children who are returned to juvenile institutions or to adult institutions once they've been to a juvenile institution, is very high. And that means that somehow the system is not succeeding in keeping children away from criminal behavior.